I would like to tell you that this presentation is based on my ongoing research focusing on labor migration-based complementary pathways funded by the Dutch Research Council. It builds, as mentioned by Pauline, on social legal research, taking Germany and Sweden as case studies. And actually, this is the first time I'm going to be presenting some preliminary findings from my field research, which has been delayed due to the COVID. So I'm looking forward to also hearing your reflections on my findings. So as Pauline said, she gave a very good introduction to what complementary pathways are in general, and also she made, I think, explicit already the relevance of the Marrakesh Compact. So I'll just take it from there and say that when you talk about labor migration-based pathways, in the definition of UNHCR, we mean safe and regulated avenues for entry and stay to another country for the purpose of employment and with the right, so leading to either a permanent or temporary residence. And just to illustrate, to give you an idea of what we mean in practice, this could be immigration systems that are already existing, but adapted to facilitate refugees' access to labor migration. This could also be new temporary or permanent arrangements for entry aiming to support refugees. Or as Pauline already mentioned, this could also be humanitarian channels providing a secure status to refugees and then facilitating access to employment through linking, for example, community-based sponsorship with an employer. So who are these pathways for? You know by now that both, I'm sure both compacts actually contain commitments to explore labor migration as a potential solution for displaced persons. And as already mentioned, the Refugee Compact focuses on recognized refugees, which leaves, I think, the GCM focusing on asylum seekers in third country, based in third countries to benefit from the measures foreseen for migrants. And I think, as Pauline already mentioned, this is the added value of the Global Compact on migration. And I would also basically read both together, reinforcing a variety, measures for a variety of people who would be defined by UNHCR as people in need of international protections, and also in the EU Pact as people in need of protection, referring to both asylum seekers or like people who haven't had formal recognition status yet, or de facto refugees, as for example, the Syrians in Lebanon or in Jordan. And actually, this is also what we see from the limited practice we have when it comes to work-based pathways. For example, NGOs such as Talent Beyond Borders operating in Jordan and Lebanon would consider also de facto refugees for the purposes of their labor migration schemes rather than just recognized refugees. So I would first want to walk into the realm of like, how could this work? What are the prerequisites for this to work in the EU context? And to remind you that due to the specific context of the EU, we need the willingness of member states to engage in such initiatives. We also need, of course, employers who have need of foreign labor. And most importantly, also willingness and informed decision on behalf of potential beneficiaries to use and embark on such labor migration pathways. We also, of course, need to take into consideration protection safeguards based on human rights standards and rights guaranteed in the international and EU law that have been mentioned already. Of course, the non-refoulement, the right to asylum, but also rights related to workers, labor rights, also contained in the EU Charter, which was mentioned by Elspeth in the opening. So what's, I would just like to give you a short introduction into the EU law picture and then move to the national examples. So what do we have at EU level under the EU labor migration directives? We have sectorial approach covering different categories of migrants, such as highly skilled researchers and students, seasonal workers and intercorporate transferees. And then we have, of course, complementing this EU statuses, we have the national immigration legislation of the member states. In the all these instruments, we have myriad of requirements for entry, even for the highly skilled migrant workers as the blue card holders, which the EU tries to attract, including through the new recast blue card directive that we are all eagerly waiting to see any minute now. So in order to make this work, we need legal and practical barriers to be removed by the member states, including by, for example, not introducing labor market tests or enforcing the provisions contained in this directive, such as granting facilitations to visa for the persons who have fulfilled the requirements of the directives. We also need to stress that these directives, due to the sectorial project we have, actually create differences in the rights of the different categories of migrant workers. And for example, highly skilled have more rights and than low skilled migrants, such as the seasonal workers. When we compare, though, the rights that potential complementary potential beneficiaries of complementary pathways will have compared to asylum seekers under EU law, we see a clear advantage of actually opening such legal channels for this particular target group. And I can talk a little bit more in the Q&A if there is interest to actually elaborate on that. From my analysis, it seems that the two possible solutions and instruments to use at the EU level are the blue card and the students researchers directive, because they provide a stronger protection for migrant workers, and I consider them suitable to be used as an instrument to develop complementary pathways for people in need of protection. However, of course, as already said, this will depend very much on the willingness of member states to really make this schemes accessible. Having said that, I think there is much more to explore at the national level, where member states have much more flexibility to actually introduce more favorable conditions of entry, as well as stronger rights. And let me now move to the final part of the presentation, where I'll give you some of the insights from my fieldwork in Sweden and Germany with key stakeholders. The fieldwork was implemented between October and June 2021. So I think they are still valid. The interviews with key stakeholders, and this includes officials from Ministry of Interior, Justice, the relevant ministries, show that there is actually no intention to create special programs for refugees or people in need of protection, and that actually what's already there, the existing labor migration law, is identified as a complementary pathway that can be used by anyone, including people in need of protection. So the interviewed expert said it's legally feasible to use what's already there. Politically, they claim that there are no special plans or special initiatives or programs to facilitate these existing regulations. And this is mainly due to the trend to a more restrictive approach in Sweden that we are seeing currently. And in Germany, it's mainly due to the new Act on Skilled Migration, which has been recently adopted and which has not really triggered much implementation due to COVID. So it seems that there's more need for more data to see how the new law is implemented before new facilitating measures are proposed. What are the limited, what are the reasons for the limited impact of the both global compacts, I would say, at national level? I think one of the reasons that was really given by many stakeholders, including, for my surprise, employers' organizations, was that we don't want to mix humanitarian and labor migration regimes. It's politically controversial. We've already seen lane switching in national legislation. We don't like that. We want to keep things separated. Other reasons that were given are we have too many refugees, and for example, in the case of Sweden, the German stakeholders are interviewed to say we don't have that much experience with resettlement and community sponsorship in terms of like organized programs. We have limited human resources, but also, of course, the impact of COVID came into play, explaining why there's not so much going on. As I said, I also interviewed trade unions and employers organizations, and here it was also interesting to see their point of view. They have diverging views. So they would say, on one hand, we believe that refugees are coming and are suitable only for low-skilled occupations, and we are generally against more low-skilled migration, as there are already refugees who need to find jobs and are struggling to find jobs. So that's why we opposed actually also having such complementary pathways that will bring more people who will be struggling in these sectors. Then, of course, another problem that was highlighted was how would these people obtain a visa? Would they obtain a visa because they're coming from refugee ascending countries? What would we do as employers if we actually hire, let's say, someone from a refugee ascending countries, and then we want to fire this person? How can we return this person? Usually with labor migrants, we won't have that problem, but here we feel that we are tapping into the responsibility of the state. Is this really what we need to do as employers? Actually, we want to have something that's really easy, like an easy system to recruit whoever we want without this responsibility. And another, I think, a very big question and an issue that has been highlighted not only by trade unions, but also by the NGOs and civil society actors that I interviewed, is the question of labor exploitation, dependence on employers, and actually deportations in the case of Sweden, where labor migrants could still be deported due to some errors done by mistakes in their contracts, for example. So how do we really want to actually put people in need of protection in a precarious status? And do we want to contribute additionally to their vulnerability? This is a very big question that needs to be also further discussed and looked into. And to wrap up, some thoughts on the way forward. As I try to, I'm finishing, as I try to elaborate, if we look at the EU law framework, we just see a pie in the sky. So we have limited opportunities under just 2 instruments that could be picked up by some member states and will probably lead to a very limited number of people in need of protection coming. If we take a look at the national level, where there are more opportunities, we see limited impact of the two compacts yet. We see that this idea of labor migration-based complementary pathways is very nascent. There's lack of sufficient information, even among civil society actors, which was to my surprise. And we also see one of the problems is that there is a division among labor migration and resettlement experts, which do not necessarily talk to each other or consider this like expertise being separate. So this needs to be also overcome to move forward, I think. I also think that there should be more than just EU support, which is currently coming through funding and meetings with national experts. I think we need to look into more national coalition building to make the most out of the 2 compacts. We currently see some in that line, UNHCR organizing, for example, such a coalition to test community-based sponsorship in Sweden. So that's, I think, a very good model. And I'll just leave this finish by saying we need to also strengthen the status and protection of migrant workers at national level in order to actually make this a feasible option, which would not make people in need of protection more vulnerable and will not actually push them into applying for asylum once they embark on such statuses based on labor migration. Thank you very much.